Happy Friday, everyone, and welcome to No Bullshipping with Hope White. Oh my God, we had such a fun week. This weather, whoa boy, it's been phenomenal, huh? So today we have back for episode 2, part 2, Miss Emily Bradford of WedLawk. Hi, Emily.
Hello, Hope. Thank you so much for having me back to the show.
I am so excited that you decided to come back.
I just felt like it only made sense. Like I've worked with you and a few others in your industry. And it's like, as I'm learning, I want to be able to share that with those, your followers as well. So
Sure, absolutely, absolutely. I know you've been such a joy and a resource to the logistics and supply chain industry on a small business side. Thus far, a lot of my counterparts are just raving about how your services are and how well they are being better prepared for the business. So, no better day than today to come back and recap some of the things that you've been working on.
yes, well, thank you so much. I appreciate everyone's kind words and
Sure.
fact that it is truly an honor to be able to serve you all and for you all to trust me in doing that.
Yeah.
With that said, I just wanted to come back and talk about two things, Hope. Really,
Mhm.
I wanted to talk about the proper the proper business agreements. Okay, and we're
Yeah.
talking service and staffing, and
Sure.
then I know we're limited on time, so if we have to do a part 3, we can do that too. But I really want for us to spend a little time talking about, ensuring compliance with the Fair Labor Standards Act.
Yeah.
When you own more than one business, and particularly what I'm finding in your industry are your brokers and transportation companies, like your broker or your businesses. So if you have like a common ownership in that, it's really important that you understand the FLSA and to ensure that you have your business operations that are, compliant to avoid any type of liability under them.
Yeah.
Yeah. So with that said, Hope, just to kind of circle back around on the business agreements, okay?
Mhm.
So
Mhm.
know that at this point, you can correct me if I'm wrong, but most of what you do and focus on is intermodal transportation, correct?
Absolutely. Yeah. We definitely do all ocean cargo, pretty
Right.
much.
And
Mhm.
so that's a little bit different than your traditional
Yeah.
instance. And so because
Yeah.
that shippers are given more discretion in who they're
Yeah.
contract with, right?
That's
And
right.
so you have a ton of different contracts that are moving around out there per se. Okay.
Yeah.
Between,
Mhm.
your shippers, your brokers, your carriers, your agents, and things like that. And so
Yeah.
most of what I've seen, and this is kind of how I wanted to break it down. If anybody is going into any area of this industry,
Yeah.
then startup business agreements, you need to ensure that you have a service agreement
Yeah.
and to the proper staffing agreement. So
Yeah.
let's put the service agreement. So if you're a broker,
Mhm.
I've worked on and I've drafted the shipper broker intermodal transportation agreement. Okay. So
Yeah. Yeah.
between your shippers and your brokers.
Right.
Also, the brokers have, I have another client that I'm sure you're familiar with. They'll have it
Mhm.
with their carriers, right? So they
Right.
start from their shippers, right?
Yes.
And
That's
so
correct.
that's your broker carrier intermodal transportation agreement. All right.
Mhm.
That's on the broker side. Now let's get to carriers like what you do.
Yeah.
Okay. So
Yeah.
most what you have, or if a shipper decides to bypass a broker and work directly with the carrier, then
Mhm.
oftentimes you're going to see that same type of, it'll be a shipper carrier agreement, right?
Correct. Correct. That's correct.
Okay. And then you also, the broker carrier agreement with the broker, right? Now,
That's
here's
correct.
sometimes these companies have their own agreements that they send to you all, right?
Yes. Yes. And we are required to take on their agreement versus our own.
Right. And that is totally acceptable in the industry. But the
Mhm.
best practice before you sign that type of agreement is to run it by counsel, legal counsel, to ensure that there are no red flags or anything like
Absolutely.
that. Now,
Absolutely.
correct. Now, in the event that you don't, you're not sent those types of agreements, then your business should certainly have their own agreements in place. And so
Right.
on what type of business you are, that's going to determine what type of agreement you need. And
Right.
that you all know why these business agreements are important, Hope, is they're laying out the terms and conditions, the obligations, the shipper's obligations, compliance with certain federal laws like hazardous, if you're transporting hazardous materials and things like that. And so it's really important that you have these agreements in place, because if you don't, I mean, you're subject
Yes.
to liability on so many different ends.
Yes, you are. Yes, yes, yes. Yeah.
Yeah.
So, and a lot of times we're, as smaller businesses, we don't really have a choice. If you just kind of like, you're kind of put at a wall there. So having someone like you in place to point out, well, this may not be a good customer for this reason, and that agreement is probably really good.
Oh,
'Cause, yeah, we
it's
don't
all,
have.
I always advise to have it looked over, right?
Yes.
You want to make sure you know what you're entering into. And then
Yeah.
if the unfortunate happens, which I mean, it does, like it's
Yes.
inevitable, then you're protected, or at least how you're protected, or what that process should look like based off of the terms of your agreement.
Absolutely.
So I just wanted to kind of make that clear. That's the services. Now,
Yes.
staffing agreements. Okay. I've seen where brokers have actually used agents, right, to go out there and do that. So there is
All right.
yeah.
I got excited about that because I know where you're going. Go ahead.
No, I just want you all to know that there is a separate agreement for that.
Yes.
There is
Yes.
a agent agreement. So
Mhm.
that you have that sets out, again, the terms and condition, the commissions, the pay, all of that.
Yeah.
And then in the on the carrier side, that's your carrier subcontractor agreement, right?
Yes, that's correct.
Right. So important there is really your insurance, your indemnification, because at any point, at any time, the drivers could, like be involved in something that causes damage to physical, property or person.
For sure. Yeah.
Always like, it's like, oh, like that's an opportunity to sue. That's an opportunity
Yes.
for money.
Yeah.
It's like,
Mhm.
okay, you want to make sure you're protected in that sense. And there's things that you want to include in those agreements.
Yeah.
To ensure that protection. So
Yeah.
now, aside from that, okay, you also, if you're not staffing with independent contractors, because a lot of you all are,
Mhm.
then the alternative is you need to have in place your offer letter, your background authorization notices and consents, your job descriptions, your employment handbook, or your employee handbook, your policy and procedures.
Mhm.
That's what you'll need in place if you're growing and you're actually staffing with employees.
Yeah.
Otherwise, your staffing agreements are going to be limited to your independent contractors, whether that's your carriers.
Can you really hit that? Because I know you opened my eyes to the difference between ICs, right? And what agreements they should have, and how we should be paying them. If there's a termination that comes up, how do we handle that, right? Because I think oftentimes as small business owners, we try to mimic what we see in the industry, or if we've worked for other trucking companies and then we started our own, we're mimicking the processes that we think are beneficial to our companies, not understanding some of those companies are self-insured.
Right.
And so they can do a lot of the things differently against the grain than what the actual law is. So can you kind of speak into what the difference with the IC agreements and everything?
I think that is a great segue into what I wanted to talk with you all about next, which is ensuring compliance with the Fair Labor Standards Act. So I think before we dive into, the do's and don'ts with employees versus independent contractors, that you all kind of understanding of what the law is.
Absolutely.
So the Fair Labor Standards Act is a federal law, okay? And essentially it does two things. It sets your federal minimum wage that you have to pay employees, and it also mandates that you have to pay overtime, right? And that's unless an employee is exempt. So a lot of times you'll see exempt versus non-exempt. So non-exempt is like, hey, they're subject to the general rule, which is they're entitled to overtime, and you have to pay them at least $7.25 an hour.
Right.
Okay. So, but the issue, so that's the Fair Labor Standards Act. The issue that I've seen and that I've worked on a lot in my legal profession is this independent contractor versus employee classification under the Fair Labor Standards Act, right? So what happens, is that a lot of times businesses think because they have an independent contractor agreement in place, that is enough for someone to just be classified as an independent contractor and for them to avoid liability under the Fair Labor Standards Act. And that's simply not true. Okay. So you can still, okay, and what often happens, especially in the transportation industry, is you'll have these independent contractors, these drivers out here that, let's say, for example, and you got these plaintiffs' attorneys out there that are literally making a living off of suing companies based off of employee misclassification.
That's pretty sad.
Right. So what they do is they take these like drivers or, ICs, and they essentially draft a little demand saying that you wrongfully terminated them and that they were misclassified as an independent contractor when they should have been an employee, and that because of that, you owe them all of this overtime, right? Yeah. I mean, however long that may be, right? And so it catches you off guard because you're like, wait a minute, they're independent contractors. They employees. But the reason that's important is because, like I said, courts look beyond the contractor agreement, and they actually look to factors such as control. Like, are you exercising control over their schedules? Is it mandatory that they have to pick up a shift? If they don't, are they terminated or let go? Do you set the pay? Is it negotiable? Do they have discretion in how they drive the trucks, or how they make a left turn? Whatever, you're dependent on expertise, right? And drivers, and that, and that's what needs to be clear, right? In your business model and between you two and how you operate the business. There's a fine line between what you can and cannot do when you're staffing independent contractors in terms of control. Okay. Now, that's the independent contractor versus employee thing. Okay. There is, we want to avoid any possibility that these people, the possibility is always there. They can sue you. Likelihood of success of them suing you becomes very, very low if you actually understand what this law is and that you operate your business in compliance with that. Okay. So generally speaking, independent contractor agreement is great. Okay. But there's certain terms in there. For example, most people, I've seen agreements out there that contain a non-compete agreement. And it's like, they're independent contractors. Like the central idea of being an contractor is having the flexibility to perform your expertise services wherever you want. So, of having this non-compete agreement within an independent contractor agreement, I never advise that. Some people, but I know that a court would not find that enforceable. Do you understand? Or if we're in, a lawsuit involving, misclassified workers, it's going to cut against independent contractor status, right? Sure, you can limit their ability if they're working for you. Like, of course, they don't need to be out there competing, but independent contractors, it's very different. And so, but on the other hand, what you can do is include a non-solicitation or a non-disclosure agreement. Is that prohibits them from soliciting your clients or your other drivers during the duration of the agreement, and then usually for a year or 2 years thereafter, right? So there's just different things that are involved in more than just having an independent contractor agreement.
I think you need, I'm just going to interrupt you right there. Sorry.
Okay.
But I think you need a whole section around ICs and small businesses, independent contractors and small businesses, because I think we really don't understand the liability and the legal ramifications there around not being properly structured and protected there. So I think WedLawk would do very well right there from building that piece out for sure.
Definitely happy to create more content. So, share content so that you all have that, like, just as a quick reference guide, when it comes to ICs versus employees. But it is something that's litigated daily. We just had a Supreme Court opinion come down regarding salaried employees and how if they're paid a day rate that they can still be considered, or they could still be entitled to overtime pay.
For overtime. Yeah.
Right?
Even salaried employees. Wow.
Yeah, salaried. So it's a constantly litigated issue.
Yeah. Yeah.
And start in protecting your business. And so with that, how much time do I have left?
Oh, we got 13 minutes, but I got a question right there.
Oh, okay. Sorry.
So with all of the information you just gave us in reference to ICs and properly structuring and understanding the different dynamics between ICs and employees, right?
Yes.
Where do you suggest, at which point, because I know what you're going to say, but I want you to say it, right?
Okay.
Which point do you suggest a small business owner obtain legal counsel before they bring in ICs? Should they bring them in before? Should you bring in legal counsel before? Or should it be?
Well, hope you know what I'm going to say. And that's the purpose of, forming WedLawk, is to have a place where small business owners can go and have an attorney that grows with them in their business, right? Yeah. And so I don't think that anybody should start a business blindsided or without counsel. But the issue is that a lot of these people are starting these businesses, on shoestring budgets. They're using, their 401k, or they're using, different things to where they feel like can't afford, and traditionally they can't, right? Like I worked in big law, right? My rate was $3.60 an hour. There's no way that some of these smaller businesses could afford that. And so with WedLawk, and we have some upcoming plans that are going to roll out, the idea is to encourage them to get counsel early on. Like when you're even thinking about like, hey, I have this idea, like I want this business that I want to get going, like what what do I have to consider? And it's like, name availability search, and like, do you know what type of entity you want? Are you looking for investors or funding? Because if so, that's going to look a lot different than, a different type of entity structure, right? And so, just I think having counsel from the beginning all the way up throughout the continuation of growth of the business, right? It's you want to grow. Like it's not to stay a small business. I hope. Some people do, they have their limits, but I'm saying like not where it's like just like you running it all the time. Like you need help for it to be successful. And to start bringing in help, that's when you start running into, now you have employment laws that you have to comply with.
Adhere to, absolutely. And I hear you when you say small businesses don't budget for that legal counsel up front, right? But I have learned at this stage in my business, we can't afford not to afford legal counsel. So that's why I was really excited to work with you and some of the packages and things of that nature that you're going to be talking about for small businesses wanting those legal services.
Yes. Yeah. So before I get into those, can I finish telling you quickly?
Girl, go ahead. We got 10 minutes. Do your thing.
I want to make sure that those that do, or that are tuning in, that have more than one business, that there's like a common ownership there, that and how incredibly important it is for purposes of the Fair Labor Standards Act to completely disassociate both businesses. Now, nothing wrong with hiring your other business and paying them through the business, right? But the issue, right, that subjects you to this little doctrine called like joint employer liability under the Fair Labor Act is that, let's say you have a brokerage and let's say you have a transportation company. Let's say your brokerage company is banking, right? But your transportation company's newer, is getting, up to speed, whatever. Let's say that you have some drivers that, I don't know, either hurt somebody, or you got sued, or they got terminated and they, sued you for misclassification. No, what I'm saying is they're going to sue, right? Let's backtrack. I'm going to give you a real case hypothetical that I had before. Okay. And it was slightly different. It was transportation, but it was in two different industries. I mean, you all are in a different industry.
Got it.
I have one company that, and I'll do this, let's just say the brokerage company. And then we have the transportation company. The brokerage company makes a ton of money. The transportation company, not so much. The transportation company, though, doesn't have any staffing because the brokerage company, their staff is the one that actually oversees and supervises
the trucking side. Come
the
on.
trucking side, right?
Mhm.
It's like terminating, and like they're told to go to them and talk to them if they have questions about their schedule and all that stuff, right? And so what happens is that this trucking company loses these truckers. The trucker's plaintiff's attorney gets a hold of them and says, "Oh, you've been misclassified. Let's sue their ass," right? So
Yes.
we're going to sue the transportation company, but
Yep.
we're also going to sue your brokerage company.
Yep.
So they're two separate companies because there's this doctrine under the FLSA that says, hey, you can be jointly liable two separate, employers for this when you run the businesses like that, right? Like, and so essentially they have to be separate, right? If you have staff for one business, you need staff for a separate business. And I'm not talking like your owners, right? Like those that have ownership. I'm talking about your officers and your employees. If you have, a supervisor at your brokerage company, that's for the brokerage company. If you executive assistant that reports to Hope for this company, that's this company.
Yes.
Saying like
that's golden. Let me simplify it for him, right?
Right.
And correct me if I'm wrong. If you got a brokerage and you got a trucking company,
correct.
The owners could possibly be the same, but the staff for those companies have to be totally different.
Correct.
Totally different employees, totally different ICs.
Have different bank. It's not even just staffing, right? You need different bank accounts. You need different governing documents. Like if have operating agreements or, meeting minutes or whatever it may look like. Everything, your books and records should be separate. Like if y'all are sharing, if you have a house, if you're virtual like I do, and you've got two companies, one needs to be locked in a different one over here and one needs to be over here. It needs to be complete. And that's, I'm solo, right? I have my other people are remote, but I'm saying you have an in-house like physical location. They need to be honestly, your transportation company should be renting a space from the other company to operate out of there, but it still needs to be separate, right? That's how you legally protect yourself. You're showing this paperwork or this document trail like, look, we're separate companies, okay? We don't have liability. This joint employment doctrine does not apply to us, right? Like we have different, bank accounts. We have different books and records. We have different staff. Bye. Peace.
But if we don't have those things, then we're tied together in the event that there's a loss or there's a civil claim that comes after one of the businesses, right?
It's very possible. I mean, you have to have a good defense attorney like
that's
me.
Golden. I love it.
I mean,
that's golden. Because I've been saying that on the internet and people be like, such and such told me. And I'm like, you're going to be tied all together in the swimming pool. Come on with it.
No, I learned that early on, Hope. Like after I did the last podcast, I met with a couple of people in your industry and I'm like, nobody's telling them, no one's educating them, no one's schooling them, because the truth is y'all are in a heavily regulated industry. And as you grow, you're going to start getting knocks on your door from the Department of Labor. They'll start investigating and looking in and making sure that everything's operating correctly, that you properly have your independent contractors classified and, operating as such. So, I mean, I'm not saying they're coming to everybody. I'm just saying, like, as you grow, things, do happen. They happen.
They definitely happen. I've been there, done that, got a t-shirt.
So there is there was a brief I wanted to share with you that I'm happy if you want to share it with your followers. And I'm having internet connections.
So you're at 23 minutes here. So we got a good 5 and we got to talk about your program.
Okay, well, I'm going to get there. I'm just going to say I'll share a brief with you all where we actually won on the 5th Court of Appeals on this independent contractor issue. Different industry, oil and gas, directional drillers, but the most important thing is the test in there that the courts use to determine whether or not you're a joint employer. It's an economics realities test, okay? And so it goes through every single factor that the courts look at in determining whether or not someone's an employee or independent contractor. And it also, the reason why I don't want to just like list them and I want you to read how we present those arguments is so that you can start thinking about how you should be operating if you're
Yes.
not already.
Absolutely.
Okay? So I'll be
Absolutely.
sure to share that with you so that you can share that as well.
Yeah. Okay. Well, I will look forward to that. We want to share that information on our site, of course,
Yes.
for all of our viewers that's just tuning in. We're talking with Miss Emily Bradford of WedLawk, and
Yes.
she's educating us on basic principles to protect yourself legally when it comes to independent contractors and employees within your business, and understanding the structuring of different agreements within your company to make sure that you're better protecting yourself. So, Emily,
Yes.
we have 3 minutes,
Yes, we do.
and I want you to talk about what you and I have discussed offline. I'm not going to say anything. I'm going to let you do it.
Okay, so in a couple of short weeks, we are super excited to be rolling out our virtual legal counsel subscription-based services. It's really designed for what we talked about earlier,
Awesome.
making legal counsel more accessible and more affordable for small business owners. And so, but because I too am a solo practice and we are only taking a limited number of spots in the beginning. That's 35. And you all will see in the coming days, if you don't already, be sure to follow us on Instagram or Facebook. And be sure to subscribe on WedLawk if you want the access code to purchase one of the subscription plans. So, but anyways, you'll see the different packages we offer, the different plans, all of them at a minimum come with a one-on-one monthly meeting. You have unlimited.
Bomb.com. Come on with it.
So you get, you're going to get a legal audit, right? Like, and that's for the higher packages. And what I mean by that is like, we have the essential startup package. That's for someone who has no staff, right? Like that's our minimum, and that's like $249 a month. Right? Next package is our essential team or our team package, and that's for like small business owners with like 1 to 4 staff members. Okay, and following that, we have our enterprise package, and that's for those businesses that have like 1 to 10, or 10 plus employees. Now, terms of spots, right? Because, there's more work involved with each plan. We're taking 20 of the essential. Okay. The startup, we're taking 10 of the team and only 5 of the enterprise. Okay.
Got it. So 35 slots. That's all you got.
That's it. We've got 35 slots. We are currently looking, but I'm very particular about who, I want to bring and make sure that they're a reflection of our overall purpose.
That's
so
correct.
In the future, we'll have more, but 35 is all we can take now. As I was saying, each of the plans will include your one-on-one monthly meeting. Okay. When you get into the team and the enterprise, we'll do your legal audits. Okay. You have biannual and then you have quarterly, and that's just making sure that your business agreements, your employment agreements,
very important.
Your business filings, everything is, protected, like all of that stuff. You also have one thing that I love that our firm just converted to a new client management system that allows us to interface more easily with our clients. And because of that, that's why we're able to offer this now. So if you're able to, meet like immediately in your client portal, you can always send unlimited consultation via messages, right?
Very good.
Yeah. And so anyways, those are just some of the perks. Now, when you get into the bigger packages, you'll get like unlimited contract review and revisions and additional discounts off additional services and stuff like that. But
all right.
There will be more to come.
Awesome. So how do we find you? Give me your IG, your website. How do we find you to sign up for these 35 packages, girl? Because I know I better be one of them.
So www.wedlock.com. And Esquire. Oh, no. Don't go to Esquire. That's my personal page.
Okay.
It's a WedLawk. Go to WedLawk.
On IG? WedLawk on IG?
And the same on Facebook. And then you should, in the near future, we'll be rolling out Legal Talk with WedLawk. And so inviting small business owners and entrepreneurs to come on and share their stories and some of the things that
Awesome.
challenges that they faced. And it's really designed to be like very raw. Like I want it to be real, so
Okay.
they know what to expect, right?
Okay.
We can really help each other, give each other a leg up,
Yeah.
So anyways, yep, that's where you can find me.
All right. Well, me and you're going to pick this conversation up on IG. Thank you all so much for tuning in to No Bullshipping with Hope White and Miss Emily Bradford. Talk to you guys soon.